The foreclosure process in New York State goes through the court system. So being in foreclosure in New York means that you're being sued and that there's a lawsuit against you. And like every lawsuit, there's two parties. There's a plaintiff and a defendant. The plaintiff is normally a bank-like entity. Bank of America, Deutsche Bank, Wells Fargo. And the defendant is the homeowner, right? So this ends up being bank versus the homeowner. Every foreclosure action in New York has to go through the court system. And the first step of this court process is called a summons and complaint. The summons is notifying the homeowner that the homeowner is being sued and that the homeowner has to go to court to fight the lawsuit. The complaint lists all of the allegations against the homeowner, including how much the loan was for, when the homeowner fell behind, how much the homeowner owes now, right? And this is the first step in that process. Depending on how you get the summons and complaint, whether they hand it to you in person, they leave it at your house, you get it in the mail, right? You have 20 to 30 days to submit something called an answer. And Karen's going to go over what that means, right, and what an answer includes. But this process, again, is going through the court system, and all of the documents that come from the court will list the plaintiff, the bank, the defendant, your name. It'll list the court that it's from. For example, the Supreme Court of Kings County, the Supreme Court of Queens County, and there'll be something called an index number. And the index number is your specific number for your lawsuit, right? That's the number that will follow your lawsuit all the way till the end. And, you know, homeowners are getting inundated with mail, right? A lot of scams, a lot of solicitations. And so the things that you should look out for and how you'll know it's a real court document is it'll list the court, it'll list the plaintiff, the defendant, and the index number, okay? So now Karen's going to talk about what an answer is and what gets decided.
So like Jay said, the first step in the foreclosure action is the summons and complaint. When you get the summons and complaint, you need to respond with an answer. An answer is a word that we know, right? It's a word that's very common. There's something very specific that the court is looking for in an answer in court. So you're responding in a written letter or you're going to court is not an answer. An answer is a very specific document. And so we have a sample here, so I'm just going to pass it around for you to take a look at. But in the answer, the main thing to know is that what makes it an answer, besides for the fact that it has this caption, which Jay said has plaintiff and homeowner, defendant, right? All court documents have this, and there's an index number over here. But the content of this answer is your legal defenses, right? All of your responses to the complaint go in this answer. You can't bring them up outside of the answer, right? This is the time when you list all of your responses. So you're actually listing the reasons that you contest this foreclosure action, right? And there are two different ways that you would contest the foreclosure action. There are two different types of things that you might say. So one is technical errors in the foreclosure process, in the court process. And one really looks at the heart of the matter, which is if the loan is legal. Most of the work that we do here is actually about technical errors. Those are the easiest ways to win. We don't want to lose sight of the main issue, but some of the strongest tools that we have are these technical errors. So some examples. If the bank fails to send you required notices, You're supposed to get notices 90 days before the foreclosure happens. You're supposed to get a specific notice when you get the summons and complaint. Before you get a settlement conference, you're supposed to get a notice. These things are required. And if they don't send these notices, this could be a reason that you get your foreclosure action dismissed. A technical and quick thing, but something that we need to be aware of, right? So if they also fail to serve documents properly. Jay talked about this, about service, how you get those documents. If they don't do things in a particular order in a particular way, that might be grounds to dismiss the foreclosure action. Proof that the bank owns the mortgage and the note. You need to be sued by the right entity, right? Not anyone can sue you. The bank needs to prove that they have the grounds to sue you, right? That's a requirement of the foreclosure process and the court process. And I'm going to put statements up here, but very many of us are familiar with this Lippman requirement, Administrative Order 43111. There are affirmative statements that the bank has to make. These are all technical requirements of the foreclosure action happening. If these technical things don't happen, you need to list them in your answer. These are your legal defenses. In this other category, we're actually looking at the loan itself. So these things, these errors, happened when you went into foreclosure. If you went into foreclosure in 2009 or 2010, these errors happened at that time. This category of defenses happened in 2006 or 2005 when you got the loan, right? So looking at what makes a loan legal or illegal. We look at to see if terms are unconscionable. Is there an 11% interest rate? Are there 2 loans instead of 1? Is this term predatory or subprime? These are things that make the loan legal or illegal. Were there misrepresentations? Misrepresentations. Did someone lie to you or induce you to take out this loan with statements that weren't true, right? And then we also are going to look at promises from the broker. So lies about the specific loan or lies about what you can do as a homeowner in the future. You could rent out the basement when maybe you couldn't, right? Yeah.
True.
Exactly. You could refinance in 3 years, right? So these are the types of things that are defenses that we would consider in the answer. And so just very quickly to finish up, if you don't submit this answer, what if those 20 or 30 days pass and you don't submit the answer? What happens, Mr. Barnes?
Order of preference.
Yeah, right, you get a default judgment. Exactly, exactly. But as many people in this room know, if that moment happens, if you get a default judgment, we can still turn back the clock. And the way that you turn back the clock, and the 2 folks that I'm going to meet with here today are going to go through this exact motion, and many already have, you need to have a reasonable excuse for your delay, right? If you miss the 20 or 30 days to answer, you have to have a reasonable excuse for your delay. And let me just list a couple of things that are and are not reasonable excuses. So, common sense does not prevail here. If you are in settlement negotiations with the bank, say you get the summons and complaint, but you are negotiating some sort of settlement with the bank, that could be a reasonable excuse for why you didn't answer. But it's not enough for you to say, I was talking with the bank on the phone, or I was submitting loan modification applications. You have to show that you were actively negotiating. I gave them this offer for a short sale, and then they rejected it, right? Very specific evidence that negotiation was happening. Another reason why you may have a reasonable excuse for missing the time to answer is that you misunderstood who the person you were working with. If you were working with a housing counselor, someone that submits loan modification applications on your behalf, if you were working with that person and you thought that they were an attorney, courts have found that that's a reasonable misunderstanding, and that maybe you didn't answer because you thought that you had representation when you did not. It's always a reasonable excuse if you hire somebody to represent you in court and they don't. You hire an attorney. This case that we passed out today with Mr. Davis Clark, he hired an attorney who did not represent him, and the court found that to be a reasonable excuse for him not submitting an answer. That also happened back there, right? So settlement conferences, when you're in settlement conferences, right, nothing happens, that's okay. You're not going to be punished for the time that you're in settlement conferences. Things that are not an excuse, I didn't know that I had to answer. Even though that's what 99% of people say, and that's what happens to most people. I got the summons and complaint, I didn't understand what it was, I didn't know what to do, and so I didn't answer. The court finds that that's not a reasonable excuse for not submitting this answer with your legal defenses, right? Or any claim that you make that you can't show. So if you say, I was working with a housing counselor, or I was working with a lawyer, but you can't give the name of the lawyer and the name of the housing counselor and the dates that you worked with them, the court's not going to accept that. So one thing that we do here at the clinic, that we do quite often, that most people in the room have had, is we write a motion explaining to the court what your reasonable excuse for the delay is and asking the court for permission to submit a late answer. So we help people submit answers on time. If you've missed the time, we help people submit a late answer. And I think we're going to take a break now. I'm going to step out with Tanja and Tarek, and we're going to talk a little bit more because both of you need this motion to submit a late answer. And just a show of hands, other people that have gone through and had this motion to submit a late answer, the Roses, that's you, right? Karan, Mr. Bowen, right? Mr. Barnes, that's one of the things you asked for today. So it's very common, not to worry.
With a lot of success.
Yeah,
A lot of success.
yeah. Definitely. So if the two of you will step out, we'll...
Karen, just
Yeah.
as bullets, could you say what those 4 answers are, as like standing, service, just as
Sure.
bullets?
Sure. So I was explaining what these legal defenses are, and so you're looking for the actual term.
Yeah.
So if you do not have the mortgage in the note, you're challenging the bank's standing to sue. If you have an 11% interest rate, or something that it shocks the conscience of the court, some terms that are shocking, we say that there is an unconscionable term. If you have a story where you were induced into signing this loan, but by lies or false statements, right, we say that there was deceptive practices used,
Oh, okay.
right? If you didn't get a notice requirement, it's a violation of the Real Estate Procedure and Property Law Act.
Wow.
If you didn't have the signed statement that says that the attorney, well, what do you tell them?
It says, 431-11.
What is the requirement?
Okay, that says that you're required to contact the plaintiff, a representative from the plaintiff who will then assure and review the foreclosure action and make sure that it's accurate and concise.
Perfect.
Wow.
These are some of the main legal defenses that we bring up in people's answers. Good, Richard? Yeah? Okay, awesome. Thank you.
So this is the beginning, right?
Right.
You get the summons and complaint, you submit your answer, maybe you do, maybe you don't, right? And then most homeowners will get something called a settlement conference, which is just mediation, an informal setting where you can try to work out a loan modification or a short sale or whatever it is that you want to do. After that point, right, you move on into actual litigation. Because up until this point, it's paperwork, right, and this is mediation, it's very informal. And then you move on to trial. You move on in front of a real judge, in a real courtroom, and you're defending your case in a lawsuit. If you submit an answer, right, the next step would be a motion for summary judgment. This motion is normally filed by the bank, and it's asking the court to grant them a judgment without a trial. So you submit an answer, you raise all of your legal defenses, and the bank will say, Your Honor, I know that this homeowner raised 4 defenses, and we're telling you right now that none of these defenses matter, right? And that you should grant us judgment as a matter of law. There's no reason for a trial. Obviously, if that happens, we will oppose that, and we will fight that. But that's what they're asking for. They're asking for a judgment without a trial. If they win, the next step is an order of reference. And this step really is the default judgment. A lot of homeowners, if they don't submit the answer, right, the bank does not even have to move for summary judgment. They go straight to order of reference. They say, you didn't submit an answer, you didn't appear in this case, we win. That's it, right? They get to this point, and if no answer was submitted, and the bank says, we have a judgment against you because you didn't show up. That's why the answer is so important. The other thing that I want to point out with the answer there are legal defenses that you waive if you don't include them in the answer. What that means is, if you go through the foreclosure process without submitting an answer, some of your legal defenses are preserved, no matter what. Just because you didn't submit an answer, it's okay. Your defenses are preserved. For example, the 90-day notice. The 90-day notice doesn't matter if you put it in your answer, you can always raise that as a defense. Improper service. You never waive that. You always can raise it, because if you didn't get notification because they didn't serve you, you should have the right to raise it, right? So the things that you can't waive are some of the notice requirements and service. Some of the important defenses that you do waive if you don't submit an answer is standing. We know that the loans that the banks were giving out were sold over and over and over again. We know that it's very difficult to pinpoint which bank owns what loan because they were selling it, right? That's an important legal defense. It's one of the best legal defenses that homeowners have. If you don't put that in your answer, you waive it, it's gone, right? And that's one of the main reasons why we put in requests for late answers, because we know that standing is one of our best defenses as homeowners, right? After the order of reference, a referee gets appointed. And the referee is just a court-appointed attorney that is just calculating. It's just calculating how many months has this homeowner been behind, what is the total amount of arrears, what are all the court costs, and they come up with a figure. The bank then moves for a judgment of foreclosure and sale, which gives them the power to sell the house at the auction. The number that they sell the house at auction is determined by the referee, right? And this is the number. They come up with $400,000. That's the minimum bid. Right? The auction is the very last step in a homeowner's journey, right? But it doesn't even mean that it's the last step in terms of the house. The minute the auction goes through, a homeowner becomes transformed from a homeowner, right? And then once the house is sold, as a tenant in what used to be their old house, right? Because now there's a new owner. That new owner then has to take the former homeowner to housing court to evict them as a tenant, right? This process in New York, on average, takes 4 years. For many folks, you know, Karen, I think you, Mr. Davis-Clark, there are cases that have been from 2007. That's 6 years. But the average in New York City is about 4 years, because like with any lawsuit, it takes a long time to journey through that court system. This entire time that you're in foreclosure, this house is your house until the house sells at auction. So that's a long time. That means this house is legally your house. You can sell it, you can rent it. You can prevent people from coming onto your property because it's your house. A lot of tenants stop paying when they realize that the
Yeah.
homeowner is in foreclosure.
Yes,
But
they do.
legally, the homeowner is in the right, right? The homeowner has every entitlement. Because this is a lawsuit. It's you against the bank, right? And until a court says the bank wins, you're not sure, right?
Right.
It's still a fight. So until there is a final judgment that says that the bank wins, which really is auction, right? Because they got to sell it, right? It's still your house, right?
I got a question, it's a
Sure.
little bit off balance. It's in that stream. The judgment of foreclosure and sale. Let's say we go through the process and we get it vacated. Because when they do place a judgment of foreclosure and sale, that goes on your credit, right? Your credit report.
Once you default on your mortgage payments, once you fall behind, every 3 months, the bank will report it to the credit agency.
Right.
So whether you're at judgment of foreclosure and sale or order of reference doesn't make too big of a difference. But there is a huge difference between being in foreclosure, being sued, right, and losing the house at an auction. There is a huge difference in terms of the impact on your credit score.
So now, when, let's say you get it vacated,
Mm-hmm.
does that help? Are you able to take it? Because I know when they put a judgment of
Right.
anything on your credit report,
Right.
and let's say you get it vacated, and is that the same?
In the foreclosure context, it's a little bit
That's
different.
Okay.
Because it's not so much about the judgment of foreclosure, right? It's about how long you're going having defaulted on a
Right,
loan,
right,
right? So that time span still remains the same,
okay.
right? But the fact that you're vacating all of these steps, right, means that you're buying yourself more time to get out of foreclosure, right? You're buying yourself more time. And there are some opportunities to use the court to get rid of some of the interest that has been accruing,
Right, right.
right? And even for a dismissal, right? And obviously with a dismissal, they can always come back and bring the case, right? But it gives you a lot of power. It gives you a lot of power to negotiate a settlement when you say to them, I'm ready to settle with you right now, here's my offer, right? Accept it and we'll save you the expense and the time of litigating this case all over again because I will fight it from the beginning next time, right? Any questions about that process? Or any questions generally?
Reading this, you know this guy, the guy was, the lawyer representing the bank,
Mm-hmm,
was Stephen Baum.
mm-hmm.
He had a lot of cases.
Yeah, he did.
And now he's out of business, but
Mhm,
when they name a new lawyer,
mhm.
that means they had to restart the process and give you a new summons and a new,
No, you can just ask for permission to step in, consent to change attorneys.
so the summons that they gave you before and
It
the
still
complaint
stands.
still stands.
Yep.
Yeah, that's what happened in my case. However, they came in and instead of going with what Stephen Baum already established, they came in saying, we'd like to vacate that. And
Oh,
install
what's
a
the new
one."
papers?
Right, right. Because
I
you know,
get-
if the attorney before me got fired and I stepped into their shoes, I wouldn't be comfortable with what they did,
Yeah,
right? But you could theoretically just step in and move
and
forward.
just follow the same case.
Yeah, that's
Okay.
right, that's right, that's right.
Jen, when a referee is set in place to determine the value
Mhm.
at which it would go to auction, you said it's the minimum bid, but does the house always sell? That minimum bid is probably going to be higher than the street value of the house.
Mhm. So what they will do, the bank will come up with a number, right, so that they're owed. So let's say they're owed $400,000, right? They can set the minimum bid up to $400,000.
Up to,
Yeah, so what they will do sometimes though, is they will set the minimum bid at 400, even though they
Right.
know they're not gonna get it, right? If nobody bids the minimum bid,
Right.
right, they just get it back. That's called an REO,
Yeah.
real estate owned property. So sometimes the banks will set the price high, which is what they're theoretically owed, but they're not owed that because it's growing arrears, right? In a normal world, if I borrow $300, right,
Right, go ahead.
and somebody sues me for $300, right, the judgment should be for $300 and maybe a little bit of interest,
Yeah.
right? But they should not be able to get $300 plus $200 of interest and fees and my house, right?
Yeah.
Because they're getting your house as a monetary value instead of just saying, you owe me $500,000 that I lent you. They're like, you owe us the house and whatever that difference is.
That's crazy.
Because if they set the bid at $400,000, right? But let's say they're saying that the homeowner owes $400,000. They set the minimum bid at $100,000, right? Somebody bids $100,000 and it gets sold. There is now a $300,000
Efficiency
difference, and they will come after the homeowner for that,
Wow.
even though they've already taken your house, right? In what universe is that fair? It's not just about the money, it's also about your house. This is why it's so important for people to get involved early in the foreclosure process, because even if you reach a point where your options run out, even when you reach a point where you get tired, right, and you've exhausted all of your possibilities, we have to prevent this situation, because then your house debt will follow you into the new life that you're trying to create. That's the biggest fear, right? And that's why we have to help homeowners come up with a resolution before this happens, because this is about control, right? You want to have control over the situation.
So if you negotiate with the bank, eventually you can agree, even you let them auction the house, not to give you a deficiency
You
judgment
can,
for the 300,000.
you can. So the easiest way to do that is through a deed in lieu.
Mhm.
I'm going to give you the deed to my house in exchange for me walking away, right?
Okay.
I'll move within 60 days, you agree to give me $10,000 in moving expenses, end of story. You promise not to come after me for this deficiency judgment. That's one way of doing it.
Okay.
Another way of doing it is a short sale. I'm going to list my house up for sale. I'm going to sell it for less than what you think I owe you, but it's the market value. You agree to forgive me of that difference. But you need the bank's permission to get rid of this deficiency judgment. Otherwise, they have the legal right to try to collect. Granted, not every lender is going to go through the process of trying to collect that deficiency, right? It takes a lot of time. Sometimes there's nothing to collect, right? So it might not always happen, but that's the fear. And that will stay on your credit report.
And, well, it's loud, but
You said that was.
I also heard-
Yeah, because your house is sold at auction,
Right, so.
right? And now you
Still
owe
owing that.
$300,000.
I also heard that if they forgive the $300,000 deficit, at the end of the year, they will give you 1099, like if you have an income of $300,000.
Not anymore, not
For
anymore.
it being a taxable.
Yeah, they used to, but with the Home Affordable Modification Program and reforms, they're not supposed to do that anymore.
Okay.
They used to though, yeah. They used to give it to you
You
as
believe
if this
that?
was
You
income,
believe that?
as if they did you any
They claim it
favors.
twice.
Right.
Not anymore, starting when?
2009 to 2010, we can find out. Any questions, any other questions about the process?
Well, as you were saying earlier on, with the, it's going from here, but more, your credit, that it doesn't remain on your credit report. Just as you say, as they go to start your new life, that it doesn't affect.
So, once the debt is over, right, then you can start fresh, right? But if you owe a deficiency judgment, and they're trying to collect that from you, they're not gonna close that out. right? And that's the problem. If you just give the deed over in exchange for a deed in lieu, right? Deed in exchange of litigation,
Right.
right? Then they'll close it. They'll discontinue the foreclosure action, right? And then they'll stop reporting it. But if you just let it go, and now you owe a deficiency, and they're trying to collect on the deficiency, that will haunt you until they get it, right?